This is a video intended to take the place of the class that we missed because of the snow, and obviously because we only meet once a week, we do want to sort of keep on track with what the syllabus provides. So what I'll do is I will use the same slides that I would have used had we had a lecture, and I will try to give the same lecture that I would have given had we had an actual class. If anyone still needs copies of the syllabus, please send me an email and I can get that to you. I had resent the slides from last week's class, and hopefully that's in a format that works for everyone. What we're going to do today is we're going to do a quick review, then we're going to move on to secured transactions, and then finally we're going to finish with talking about garnishment. So I wanted to start out with a little bit of a review of the Fair Debt Collection Practices Act. We talked about it at the end of last class, and I think it's a very important tool for anybody who is representing debtors, and it's also important to know about if you happen to be on the creditor side. And so I want to put a few fact scenarios to you. Obviously, if we were in class, I'd be asking you to vote with your clickers, but for these purposes, just think about the answers that you would have given. And the first fact scenario is you have a client who comes to you and they say they bought a couch from Slumberland. They can't pay on it. They bought it on store credit. And Slumberland has been calling them up and telling them that if they don't pay, they're going to send them to jail. And so your question is, does this violate the Fair Debt Collection Practices Act? And the answer to that is actually no. And although it's outrageous statement and not accurate, it's not covered by the Fair Debt Collection Practices Act because that act only covers third-party debt collectors. It does not cover the original creditor itself. So in this case, although Slumberland may have other liability, it does not capture them. The second fact scenario, a collection agency calls your clients, and your clients say, well, I asked the collection agency to send me a validation notice because I didn't recognize this debt as being one of mine. And on the phone, they told me that if they sent me that notice, that they would go ahead and they were going to sue me for the whole balance. And so that I probably shouldn't be asking for that notice. Because if I didn't ask for it, then they might be willing to settle with me. And so your question is that a violation of the Fair Debt Collection Practices Act? And the answer to that, I think, is yes. A collection agency is covered because they're a third party. And they're required to send a validation notice. Your client doesn't have to ask for it. They're required to do it. And what they're not able to do is to, number one, not send the notice, and number two, to threaten the client or to threaten the person by saying, well, if we do send it to you, then we're going to take you to court. That's not permissible under the Fair Debt Collection Practices Act. Third fact scenario, and again, same question, is there a FDCPA violation? Third fact scenario, you get behind on a credit card balance and a collection agency starts calling you. And they say, well, your balance on the credit card is $1,200, but you need to pay us $2,100 because our firm has had to add on a collection fee of $900. And so the total balance that you owe is now $2,100. Is that permissible? Is there a FDCPA violation here? And the answer to that is yes, there is, because one of the provisions of the FDCPA is that a creditor can only try to collect fees that are authorized. And so they cannot arbitrarily add on a $900 collection fee. So it would be a violation for them to try to collect that fee. All right, so much for review of the FDCPA. We're going to move on to talk about post-judgment collections, which I sort of summarized as, okay, you won, now what? And the basic idea of that is that it's all fine and well to have a judgment against someone that the court has awarded you, but there is nothing particular about a judgment that gets you any money. And so figuring out how to turn a judgment into actual money for yourself or for your client is really the point of this. And so when we talk about secure transactions, when we talk about garnishments, that's really what we're focusing on is how do you turn this into a recovery for your client. This slide is kind of an overview of the remedies available to a creditor, and the takeaway point, or one of the takeaway points I think, is how much better it is to be a secured creditor than an unsecured creditor. And I think this hopefully helps to illustrate that. With a secured creditor, you have all the options of an unsecured creditor plus more. And so basically, if you're a secured creditor, you have certain remedies that are unique to your status. And those are outlined on the chart. And so, for instance, you can peacefully repossess and sell property. You can't go breaking in, you can't go breaching the peace, but you can effect a peaceful repossession, and then you can go and sell the property. Alternatively, you could also replevy the property and sell it. And those are really just two sides of the same coin. You're still getting the property back. With a replevin, you're having a court order to help you do it. With a peaceful repossession, it would be a self-help remedy. But in any event, if you are a secured creditor, you are entitled to take back whatever property you have as your collateral. You can't take back other property. So in other words, if you are the auto lender and the car is your collateral, and the person you loaned money to falls behind, you can take back that car. Doesn't mean you can take back another car, doesn't mean you can take back their house. You are limited to your specific collateral. But as a secured creditor in that collateral, you're entitled to take that collateral and sell it. You're also entitled to keep it under some circumstances and have that satisfy the debt. So basically you have additional remedies that an unsecured creditor does not have. Now typically what happens with a secured creditor is, let's say it's an auto lender, the person falls behind, they take back the car, they repossess it. What they'll do is they'll turn around and they will resell it to someone. Now with the nature of cars and how quickly they depreciate, it almost never sells for what is owed on the loan, and so there's almost always a deficiency. So a secured creditor may eventually find themselves with what's called a deficiency that they have to pursue the person for. So let's say the car was repossessed, there was $10,000 on the loan, the car sold for $4,000. Okay? So the secured creditor now has a deficiency of $6,000. As to that deficiency, they're an unsecured creditor. They've already had recourse to the collateral. It didn't satisfy the debt. So they become like an unsecured creditor as to that deficiency. And as the arrows sort of indicate, they fall right back into the status of an unsecured creditor at that point. However, at least they've had the benefit of going after the collateral and getting the benefit of that collateral. That's not something an unsecured creditor would have done. Now, an unsecured creditor has certain remedies, and so typically what they're going to have to do is they would have to sue on the debt, file a lawsuit against the debtor. They would have to get a judgment against the debtor, and once they get that judgment, there are several things they can do with it. Absent getting a judgment from a court, there is not much an unsecured creditor can do other than calling the debtor, sending them letters, and sort of informal collection methods in that way. The only way an unsecured creditor can collect in a more formal manner is if they sue and get a judgment. They can't really do anything without a judgment. Now, similarly with that secured lender, they don't have to get a court order to repossess. However, If the sale of the collateral is not enough to satisfy them, then they're in the shoes of an unsecured creditor, and they do have to go to court to try to get a judgment for any balance that's owed on that amount. Once a creditor gets a judgment, they have a couple options as far as what they can do. Probably the most common option is trying to get a garnishment, and we'll talk about that more. But basically what they have to do is they have to get an additional court order permitting them to garnish either wages or a bank account. They also have the option to record the judgment against real estate, and what that means is that in the property records for the locality, the judgment would show up in the property records, and so whenever the debtor goes to sell that property, it will come up as a cloud on title. And so when a title insurance policy is, when they're trying to underwrite a title insurance policy, this will come up as something that needs to be cleared. And so if you have a judgment against someone that's recorded against their real estate, you may not get your money immediately, but if that person goes to sell the real estate they own, there's a very good chance that you will end up getting paid off on that in the longer term. This obviously only works if the debtor has real estate that they own. Another option that you have once you have a judgment is to execute on property. And why do you execute on property? Because you're trying to become a secured creditor. So I don't want to get into too much more depth on this because we will talk about it. But the takeaway from this is that the reason we do an overview of secured transactions is because secured creditors do so much better than unsecured creditors. And I think you have to understand a little bit about what that means, because they have different remedies, they have different options, and consequently they have different outcomes. And so the takeaway from this is that if you are a secured creditor, you have additional options over and above those which an unsecured creditor has. All right, so let's move on to an overview of mortgages and security interests. If you've already taken secured transactions or real estate transactions, a lot of this will probably be review to you. Nonetheless, I think it's a helpful review because it helps you to understand the points about secured transactions and real estate that will be important in bankruptcy. If you have not taken either real estate transactions or secured transactions, this may be a little more difficult. It may be newer material. However, that's fine. There are only bits and pieces of each of these subjects that you really need to know for purposes of this course. I think it's helpful not only for understanding bankruptcy, but because if you do go on to take a bar exam in another state, almost certainly there will be essay topics relating to secured transactions. And so this high-level overview of the subject will probably come in handy later on outside of the bankruptcy context as well. We're just going to touch on some of the main topics. I'm not going to get into great depth on some of it. If you are interested in the topics, or if you do end up going into bankruptcy, I would encourage you to take both real estate transactions and secured transactions, or at the very least to study them, whether that's taking a CLE when you go into practice, reading some materials on that. But it is very helpful to understand that and to get into more depth on it. So why do we care about secured transactions and real estate transactions in bankruptcy? Well, we really care for two reasons. The first and probably most important reason is because your status determines who gets paid in bankruptcy. So secured versus unsecured, mortgage creditor versus non-mortgage creditor, that's going to determine who gets paid in bankruptcy. It's also going to have a lot to do with what remedies you have, both outside bankruptcy and inside bankruptcy. So, for example, there are some tools within bankruptcy or some objections that can be made that are only available to creditors who stand in certain shoes. So as we'll see, there's not much you can do to change your status once a bankruptcy has actually been filed as a creditor. But your status going into the bankruptcy is very important because it's going to determine, do you get any money, and what can you do if you don't like what's going on in the bankruptcy. So touching on the issue of why is it important to know anything about secured transactions in bankruptcy, it's particularly important in the case of Chapter 11 cases. So in other words, a Chapter 11 case, like we talked a little bit about last time, is typically a business reorganization. And you often hear about in news accounts of, of what creditors are getting in a Chapter 11 and those sorts of things. Here's a very concrete illustration of why it's important as to whether you're secured or unsecured. So in Chapter 11, there was a study done, I believe, in 2007, and it talked about how creditors do in the average Chapter 11 case. And one of the conclusions they came to was that secured creditors average a payout of 92.1 cents on the dollar. So in other words, a creditor that, let's say, a secured creditor that hypothetically was owed $100 by the debtor in a Chapter 11, on average they would get $92.10 on that claim. And that's a pretty good outcome. So secured creditors on average in Chapter 7 are doing pretty well. By contrast, the study found that unsecured creditors average about 52.3 cents on the dollar, or 52.3% of their claim. Now that number is actually, I think, distorted quite high. As we'll talk about later in the class, in other class sessions this semester, there is what's called priority and non-priority creditors. Now, most of your unsecured creditors are going to be non-priority. There are some who will have more of an elevated status, and that may be because they're tax creditors or because they have delivered goods to the debtor prior to the filing, or they've provided financing to the debtor. We'll talk about that more in depth, but the point is that this 52.3 figure is skewed upwards because some creditors get more favored status when they're unsecured. Your typical unsecured creditors, who would be those creditors that the debtor went into bankruptcy owing money to, they often do considerably worse. So just as two fairly recent examples, the Bally Fitness chain. In that Chapter 11 bankruptcy, unsecured creditors got 1.54 cents on the dollar. So if you went into that bankruptcy and let's say you were a customer of Bally's and you were, they owed you a refund of $100 on your membership fee, the end result of that bankruptcy would have been that you were not going to do very well. You were going to get a very paltry payout from the Bally's bankruptcy, and in fact so negligible that it would almost amounted to nothing. Similarly, there was a case, Chapter 11 case of the Boyd's Bears Company. So they make teddy bears. Unsecured creditors did slightly better there, but nonetheless it was only 28 cents on the dollar. So again, if you happen to be an unsecured creditor in that bankruptcy case, you are not going to do very well. So I think the takeaway from this, again, is why do we care about secured transactions? We care because if you're a secured creditor in a bankruptcy, you're going to do an awful lot better than an unsecured creditor. And so it's important to know, how do you become secured? What makes that status so special? So a security interest. What is a security interest? The citation at the top, this 1-201, should hopefully be familiar, certainly to anyone who has taken the first year contracts course. This is a UCC citation, and secured transactions are a part of the UCC just like contracts are. So contracts are Article 2 of the UCC, secured transactions are Article 9 of the UCC. And so from state to state, because it's based on the Uniform Commercial Code, typically you'll find that the rules, the laws that govern secured transactions are very similar state to state, again, because it's geared to be a uniform law. There will be some variations state to state, just as there are with contracts, but overall secured transactions are generally pretty uniform from state to state. And again, if you've taken secured transactions, this will be a bit of an overview for you. Basically, the idea of a security interest is an interest in personal property or fixtures that secures payment or performance of an obligation. And I think two very common examples that we can all relate to are if you go to buy a car, and let's say you go to the dealership, and most of us, we need to take out a loan to afford that car. And let's say the dealership is the one who's going to finance the purchase. They're going to loan you the money. And to protect themselves, what they're going to do is they're going to take a security interest in that car that you're driving off the lot. And so you're going to give them an interest in personal property, meaning your vehicle, and it's going to secure payment. So what that means is that you're giving them an interest in that car, and the reason you're doing that is to make sure that you're going to pay them the money. Another example would be the stores like Rent-A-Center. And you go into Rent-A-Center, and the idea is that you're taking home something. Let's say it's a bed. And when you leave a store like that, they're not going to just let you leave with the bed, because the whole idea of the store is that you are renting it, rent to own, so in essence you're buying it on credit. What they will do before you leave is they will have you sign a security agreement that provides that Rent-A-Center has an interest in that personal property. So in other words, they have a security interest in that bed you're leaving the store with. Why do they have it? Well, because it's securing payment. So in other words, they're not just going to let you walk out of the store and hope you pay them back. They're going to have something in writing that says, this is our collateral for the loan we're basically making to you. If you don't make your monthly payment obligations, then we have a right to come and take that back. So that's the general idea of what a security interest is. The other topic that we'll touch on is mortgages. Now, mortgages are technically not treated as secured transactions. Interest in real property are treated somewhat differently. But the general idea of a mortgage is that, this shouldn't be a surprise to anybody, it's a loan that's secured by real property and paid over time. So again, the idea it's you go to buy a house. The lender doesn't just lend you the money and hope that you pay it back. They're going to take an interest in the property, in the real property, and if you don't make the payments over time, then they have recourse against the property. So mortgages are technically not governed by Article 9 in the same way that secured transactions are. Mortgages and real estate property law are more a creation of state law. So you're going to see a lot more variations from state to state in how mortgages and real property interests are governed. Nonetheless, the general idea is the same, and so for our purposes in this class, it's sufficient to sort of do a general understanding as far as how does someone fare if they have a mortgage versus if they do not. All right, so moving on to sort of starting our overview of secured transactions, one of the bedrock ideas of secured transactions is the idea of attachment. And attachment is basically how do you get a security interest. Hopefully if you've taken secured transactions, this is something you know by heart, because this is really the fundamental of secured transactions. So attachment, how do you get a security interest? You need three things to get a security interest. You need value, you need rights, and you need an agreement. What does that mean? And the mnemonic that at least I was taught in secured transactions cost is VRA. Value. That means in order to have a security interest in something, you must have given the debtor value. And so if you go to a car lot and the dealer makes you a loan, they have given you value. You go to Rent-A-Center and they sign and you do a financing and they let you walk out of the store with a bed. They've given you value. So if you don't give someone something of value, you don't get a security interest. Rights. That means the debtor has to have rights in the collateral. In other words, you can't take a security interest in something that is not the debtor's to give. So in other words, I cannot give you a security interest in my friend's ring. I don't have any rights in it, so I couldn't give it away. The third thing you need is an agreement. and that is a security agreement. Doesn't have to be formal. It doesn't, I should say it doesn't have to be on a specific form. It doesn't have to have a specific format. What it does have to have is generally it has to be a writing, and it has to lay out that I, the debtor, give you, the creditor, a security interest. Now, it doesn't have to necessarily use all of those words. It can be much longer. It can have variations on it, but generally there has to be that agreement. Now, if you took secure transactions, you talk all about cases and circumstances where do you have to have a writing or not, but generally the idea is, and most of the time what you'll see in bankruptcy is there's some sort of written agreement. So if you went back and you looked at the financing documents you signed with your auto lender, the chances are extremely good, I would bet you anything, that there is language in there providing that you grant them a security interest in that vehicle. If you don't have one of these elements, you do not have a security interest. You have to have value, rights, and an agreement. Alright, so on the topic of attachment, I want to start going through the questions that were in the handout I provided to you guys. The source for this handout is actually something that Judge Martin used to use when he taught bankruptcy. When I taught 3 years ago, I used it, and I thought it was very helpful because it's sort of a quick global view of secure transactions. It tells you as much as you need to know. The source for it is the Turnaround Management Association. And basically what that is it's a group that tries to educate people who do turnaround management. And those are people, not necessarily lawyers, in fact often not lawyers, but their aim is to work with companies that are in distress, literally to try to turn them around. And so people come into this with all sorts of different backgrounds. They may have a legal background, they may have an accounting background, they may have a business background. And so what turnaround management does is they try to provide the fundamentals as far as educating people in here's what you need to know to more effectively work with failing businesses. So they have educational materials. This is the materials that they use to try to educate folks about what they need to know on secure transactions. And so it's sort of written not necessarily for a legal audience, and I think that makes it particularly easy to read and to understand. So turning to those questions, the review questions. So question 1A, it gives you a fact scenario about a bank that filed a financing statement on May 1, entered into a security agreement on May 15, gave a check on May 20, and the mill was delivered on June 1. And so the question 1A is, when did the bank have a security interest in the mill? And this relates to the question of attachment. I think the answer to this is, I think the best answer is probably D, although C I can understand. Certainly not A or B though. And the reason it's not A or B is because on May 1st and May 15th, the bank clearly had not yet attached. And you cannot have a security interest until you've attached. So that's why A and B are certainly wrong. If you chose C because you thought that at that point Jones had some rights in the rolling mill just based on, having ordered it or something like that, I can see, and you're thinking on the right track. I do think D is the better answer though, because we know that on June 1 there was clearly rights in the mill. So everything, the stars are all aligned as of June 1. There's a security agreement, the agreement on May 15. Value is given on May 20, and we know for sure that the debtor has rights as of June 1. So I think on balance, D is the best answer. All right, so question 4 also talks about attachment. And question 4 says that the debtor is going to acquire a company on December 1. It tells the bank on June 1, so 6 months ahead of time. On June 1, the bank makes a loan to the debtor, secured loan, takes a security interest in ABC Electronics, has a security agreement, files a statement. In October, the debtor defaults and the bank forecloses. Does the bank have a security interest in ABC Electronics? And the answer to that is no, it doesn't. And the reason it doesn't is because the debtor has no rights in the collateral. That's like what I was saying, about I can't give you a security interest in my friend's ring because I have no rights in that ring. I can't give away what's not mine to give. Same here. Even though the bank sort of got all its ducks in a row prior to this acquisition on December 1, the acquisition never happened. We never got to that point. And so the bank can't do anything. It has no security interest in ABC Electronics because the debtor never got to this point. It doesn't have anything to give. Okay, question 5, similar issues. February 1, debtor signs a security agreement giving the bank a security interest in inventory. Bank files. Bank doesn't have to advance any funds until the debtor asks, and the debtor does on March 1. And so the question is, during that month of February before the bank makes an advance, does it have a security interest in the inventory? I think the answer to that is probably no, and the reason would be that we're missing value here. In other words, the bank hasn't given any value. It hasn't loaned any money. Now, I can imagine some people saying, well, the promise to loan money is value in and of itself. And I understand that. At the same time, though, kind of think about how this would play out. So let's say, let's say in the month of February, something happened. How could there ever be a default? In other words, there's nothing for the debtor to pay back, so the issue of whether there's a security interest probably never arises in February. Let's say somebody else gets a security interest in the inventory in February. This sort of shades more into priority issues, which we'll get to in a few minutes. But again, as of February, the debtor, they don't owe the bank anything. The bank hasn't given them any value. So I think the better answer is that no, there's not a perfected security interest because there's been no value. Okay, so we talked about attachment. Another big concept, perfection. Attachment means how do you get a security interest. Perfection means how do you protect yourself as against third parties. So in order to have a valid security interest against the debtor, you have to be attached, but that only gets you a security interest as against the debtor. Perfection is how do you extend that security interest to protect yourself against third parties who might come along. Now there's a lot of different ways to perfect security interests, and some of them are particularly tailored to the type of thing you're taking a security interest in. When you study secure transactions, you get into tremendous detail about letters of credit, bills of lading, things like that. We don't need any of that level of detail. Suffice to say that there are several methods of perfection. Among those would be filing, possession, automatic perfection, having control of something, and having a notation on the title. Title in many ways is probably the one that we're all most familiar with. And again, going back to the example of having an auto loan, typically if the lender has, they've loaned you money for the car, you're not going to have the title to the vehicle in your possession. Your lender is going to have that. When you make your last payment on your car loan, the lender will send that back to you. The reason they do that is because the lender puts a notation on the title that says, we have this car is our collateral. That's how they perfect their security interest in a vehicle. So that's a very common one that many of us are familiar with. In the world of business and people making business loans, filing is probably the most common way of perfecting a security interest. It works on the largest category of things. It doesn't work on vehicles. It does work on equipment, inventory, supplies, farm equipment, tools. All sorts of things like that can be perfected by a filing. What does it mean to file? Well, it means you fill out a form. This does vary a bit state to state as to how you do it. Generally, you can do it by mail, Or you can, in some states, you can also do it online, and it's a UCC form. And what you do is it's a form you fill out. It says who you are, who the debtor is, and what you claim you have a security interest in. And then you file it typically with the Secretary of State's office. Well, at least here in Iowa, or where I am in Iowa, it's the Secretary of State's office. In Wisconsin, you'd file it with the Department of Financial Institutions. So every state has a particular agency charged with accepting and indexing these. And most states are pretty good about having an online index for these. If they don't have an online index, they would certainly have a paper index. The whole idea is that if you are a bank and somebody comes along and says, hey, will you lend me money for my restaurant? There is a system by which you can check to see if anybody else has taken collateral in that person or in that business. So in other words, if someone comes along and says, well, I'd like a loan for my restaurant, and by the way, I'll give you all of my restaurant equipment as collateral, you as the bank want to know, has this person gone to any other banks and done the same thing? Am I going to be first in line for this collateral if something goes wrong, or am I going to be second in line? And so what the filing system does is it provides a standardized, centralized way to determine if there are any valid security interests, perfected security interests that bind this stuff you're thinking about lending against. And so what you can do is you can search by the business name or the person's name, and it should indicate to you whether anyone else has taken this stuff as collateral. That's the whole idea of the filing system, is so that it is transparent to lenders as to whether this stuff has already had loans against it. Okay, so perfection ties into question 1B, and so it's the same fact scenario as we had in question 1A. Filed a financing statement on May 1, security agreement May 15, value given on May 20, and the goods were delivered on June 1. The question 1B asks, when was that interest perfected? And so the answer to that is D. It was perfected on June 1. Now, the reason for that is because your security interest isn't quote-unquote perfect without attachment. So I'm guessing some people might have thought, well, it was perfected on May 1 because that's the date they filed. And you're right that that date is important. However, that's not the date it was perfected. They did not have a perfected security interest until they took all the steps to attach it. Now, it's good to file early, as we'll talk about in a second, but your security interest is not perfected. It isn't perfect without attachment. So you have to go through all those steps, the ARV, agreement rights value, in order to have a perfected security interest. And again, why do we care about perfected? We care about perfected because that's how you have a valid interest against the rest of the world. If you've attached, yes, you have an interest valid against the debtor. How do you get an interest that lets you fight off any third parties, whether it be competing lenders, whether it be the trustee in bankruptcy, as we'll talk about later? You do that by going through, by attaching and then perfecting it, whether by filing or whatever other method the UCC prescribes. Question 1C, and here's where the filing date kicks in. Question C asks, as of what date was the bank's priority established? And so here the answer is A. It's May 1. That was their priority date. The takeaway lesson is file early, because even though you're not perfected until you've gone through all those steps, so you're not perfected until June 1, once you perfect, you get to date back to your priority date. So you get a priority date of May 1. And so the reason why it is important to file early is because you want that earlier priority date should somebody else come along in the meantime. Because let's say the bank had not filed that statement until June 1 when all the steps of attachment were completed. Well, they don't get a priority date past June 1 then. That's their priority date. Here, they get to date back their priority to May 1. So it's important to file early. All right. Jumping to question 7. This talks about, it goes to sort of the validity and the usefulness of the UCC filing system. As I said, the whole purpose of the UCC filing system is to provide an easy, centralized way for people to look up and figure out, is this person, have they already given this stuff as collateral? And so what question 7 gets to is, how do you maintain the integrity of that system? And the rules that have developed have basically put some constraints on how long your interest will be valid if the information is not accurate. And so question 7 says, Bank X files a UCC, it names Franklin Furniture, company goes and changes its name to Classic Furniture. 6 months later, Bank Y files a UCC covering Classic Furniture. And so at that point, at the 6 months point, who is in first position as to Classic Furniture? Because Bank X never updated its filing statement. And so, understandably, when Bank Y goes to file its statement or goes to make its loan, it probably searches for Classic Furniture. It doesn't see anything, thinks it's okay. So who is out of luck here? And the answer here is that there's a 4-month grace period. So for the 4 months after the name change, Bank X still has first priority. So for 4 months after the name change, it's Bank X. After that 4-month period, it no longer has a valid, or it has what's called seriously misleading financing statement. So as of the moment Bank Y files, which is after the grace period, Bank Y has priority. And so the takeaway for a lender is you have to keep on track of who you've lent money to. You probably want to have some covenants in your agreement that provide that the party you've lent money to needs to update you with any name changes, but you need to keep on top of it, because if you don't keep it accurate and updated, you can lose your priority. The integrity of the system revolves around having correct names. Just to quickly touch back on perfection, as I said, there are numerous kinds of perfection. I don't want to go into a lot of depth on this because we could spend hours talking about it. I did want to briefly mention automatic perfection. Automatic perfection is something that typically it's for a limited amount of time, and it provides that a person doesn't have to do anything. They're perfected without doing anything. There's a grace period, basically. So if you have lent a person money to buy something, let's say you're the car lender, you finance the car purchase, you get a grace period. If someone has sold your collateral and there are proceeds, there's a grace period. If you have a lien and it says, we have a security interest in everything you own now and everything you acquire in the future, you get a grace period. You get, it's automatic. In that case, it's automatically perfected. You don't have to do anything further. So just to briefly touch on what's automatic, there are certain types of things that are automatically perfected, often for a limited amount of time without having to do anything. All right, sort of the last of the 3 big points on secure transactions: priority. Who's first, second, third in line? Big points, big picture. Here are the takeaways. Number 1, secured is better than unsecured. If you are a secured creditor, you will do better. You will have higher priority than an unsecured creditor. Same thing we'll find to be true in bankruptcy. If you're a secured creditor, you're going to do a lot better than an unsecured creditor as far as getting paid. Second big takeaway, perfected is better than unperfected. And basically, you are going to be protected against third parties. If you've perfected your interest, you're not going to have that same level of protection if you're unperfected. That's why filing or notations on title or doing whatever, it's important. Third big takeaway, if your interest is unperfected, beware of avoidance. This will come into play in bankruptcy, and we'll talk a lot about this. Beware the trustee in bankruptcy if you have not dotted your I's and crossed your T's on your security interest. Because if you've done anything wrong, you can be knocked back to be an unsecured creditor. The technical or the phrase that's used by the bankruptcy court is that your interest is avoided. And so this is why, whether you're a creditor or a creditor's attorney, or whether you're a debtor's attorney, it is very important to examine and make sure that everything has been done correctly with a security interest. You want to make sure that it's the correct name, that the name is spelled correctly. If you are in Wisconsin and you are a bank lending money on a mortgage, you want to be sure that both the husband and the wife sign that mortgage. It has happened many times that a trustee in a Wisconsin bankruptcy case has avoided a mortgage because both husband and wife have not signed that mortgage. What does that mean if it's avoided? It means you're not a secured creditor anymore. You're not entitled to the money, the priority, and the other things that come with being secured. So, very important if you work for a bank, if you're a creditor's attorney, or if you're a debtor's attorney sort of assessing the validity of a security interest, you must make sure you've done everything correctly. Okay, question 6. Not going to spend a lot of time on this. But basically the fact scenario is Bank X sends in their filing statement on September 1. For some reason, the Secretary of State's office delays, doesn't file it till October 1. Bank Y sends it in on September 15th, gets it filed right away on September 17th. Who's first? Well, the answer is B. It's Bank Y, and the reason is that the date that matters to us is the filing date. It is a bad outcome, unfortunately, for Bank X, but their recourse is against the Secretary of State's office. It's not against Bank Y. They're just out of luck. Now, again, this shouldn't happen often because recording systems, generally you can do it electronically. You can check the status. You can get, a receipt. But in this case, it just really doesn't matter that there was a screw up in the filing. It's whoever files first gets the priority. Okay. Coming back to the chart that I had earlier in the lecture. Again, I hope it's become clear, or that there's a takeaway that secured is better than unsecured because you have more tools in your tool belt. The threat of repossession and the fact of repossession are tremendously powerful motivators to get people to pay you. Even if they don't pay you, the ability to sell that collateral without having to get a court order is a tremendous tool. Question 3 in the handout asks, can a secured creditor retain property it's repossessed? Yes, it can, and I think I said that in the previous slide. In this slide, you'll see I've added an arrow that says yes, they can repo and keep in satisfaction. There are some constraints on that. There's notice that's required to be given and that sort of thing, and you'd find more details about that in Article 9. But yes, you're not going to see this happen very often, because why would a bank want to repossess your car and keep it? That usually is not going to make any sense. They want the money, not the car. I suppose it could happen sometimes, though. There could be a fact scenario when that would happen. And again, it's just another tool that is available to a secured creditor. Okay, so we're kind of switching. We started class with the overview. We did an overview of secured transactions. We're going to transition into the rest of the materials for today's class, which talks about some state collection remedies. And you'll remember in the slide I just had up, it talked about, okay, you're an unsecured creditor, your person hasn't paid you, what do you do? Other than calling, sending letters, your next recourse is you have to file a lawsuit and get a judgment in court. Once you have that judgment, what do you do with it? That judgment alone is not going to get you anything. And you have some options as far as what to do. One of those options is executing. Why do you execute? Because you're trying to become a secured creditor. The process of execution, which basically means sending the sheriff out to levy, that's the term they use, to levy on items of property, that's because you want to become secured in those items of property. So again, pointing to it's better to be secured than unsecured, the purpose of the execution remedy is to become secured so as to improve your status. If the sheriff goes out, levies on a pickup truck, you become a secured creditor in that pickup truck, and then you have the remedies of a secured creditor, meaning you can sell, you can keep it, and those sorts of things. That's why execution is used. Again, these remedies are creations of state law, and so Wisconsin will have specific and unique provisions about execution that will be distinct from California, from New York, from any other state. It's a creation of state law. What does it mean to execute? Well, again, it's going to vary by locality because this is state law driven. But basically what you have to do is after you get a judgment, you have to get the judge to sign off on a court order for an execution, and then you have to send, at least in most locations, you have to send something over to your sheriff's office that asks them to execute on property. Now this works best when you know that there is property that's out there. If you, can you send the sheriff on sort of a fishing expedition? Well, it's not probably going to be real successful. It works better if, let's say, your debtor, they're having an auction. Their restaurant's going under, they're going to auction off their stuff. That might be a scenario when it works well. One of the cases that you read for today, somebody has a pickup truck. When there are concrete items that you can tell the sheriff to look for, that's when it's going to tend to work better. Now, if you live or work or practice in a very urban county, are you going to have much luck in sending the sheriff out to execute on stuff? Probably not. This all depends on the particulars of your locality, but you're probably going to have a lot better luck if you are trying to execute on somebody in a rural county because your sheriff is going to have more time on their hands. If you are trying to execute on a debtor who lives in Cook County in Illinois, are you going to get the sheriff to take much of an interest? I doubt it. I really doubt it. And so that is one of the reasons why execution is not always a remedy favored by creditors. Another reason that it is not favored is because every state provides exemptions. We'll talk about this later in the semester because it comes into play in bankruptcy as well. But every state has exemption laws, and those are things that are exempt from execution. Creditors cannot execute on them. They cannot take them away. And so if you're a creditor, you could find yourself in a sticky situation. Let's say you send the sheriff out and you tell them to execute on your debtor's pickup truck. Well, Wisconsin has a motor vehicle exemption up to a certain dollar amount. And so if this is your debtor's only vehicle, they're going to be able to object to the court that, hey, he took this thing and it's exempt under state law. And as a creditor, you could find yourself on the hot seat for that. So exemption, it has its place. However, for most creditors, and certainly for out-of-town creditors, let's say it's a credit card company that has a judgment against you, you're not going to see execution favored very much. The illustration on this page you'll see is a very old writ of execution that uses that term of fieri facias, which you see in your textbook. And again, it's just an example of the sort of writ that would go out for an execution. How does an execution physically work? Well, you have to get the order to the sheriff. Probably helps if you have a good relationship with the sheriff's office too. The sheriff looks for non-exempt property and seizes it. The term that you'll see is the sheriff levies on it. Now, the case that you read, the Broken Bow case, says that under that particular state's law, a levy can be affected by the sheriff simply asserting dominion over the property. That's an uncommon situation in most states. To affect a levy, it actually has to be in the sheriff's possession. So in most states, if the sheriff was going to go out and levy on a vehicle, they're going to have to take that back in order to affect that. The rationale being, how is anybody going to know that the property has been levied on just by the sheriff coming out and speaking some words? After you have, let's say the sheriff goes out, finds some stuff, levies on it, takes possession of it, what do you do with it then? Well, You as the creditor can get it sold, and you would get paid from the proceeds. Now, you only get paid after any higher priority interests. And again, this only applies to non-exempt property. So let's say, for example, you were a creditor and your debtor owned a restaurant. They were doing an auction of the restaurant equipment because they were going under. And let's say exemptions were not an issue. This is all non-exempt stuff. The sheriff goes out and levies on all the kitchen equipment and tools. It's sitting in a warehouse. You're entitled to sell it and get paid from the proceeds. And so if you sell it off and it brings $10,000, you get to keep as much of that as necessary to pay you. Now, let's say that another bank had a security interest in those items of equipment. You don't get to keep it. Whoever has the highest priority interest gets paid first. So by executing, you can't somehow void or step over top of somebody else's security interest. What you're doing is, if you find something or get the sheriff to find something that has some value to it, that is not protected by exemption law, and that nobody else has a higher priority interest in, yes, you can sell it and get the proceeds. But as I hope is clear from all the sort of exceptions and qualifications to this, execution has a lot of hurdles to it. It is not by far the easiest remedy. If it works, it works, but it is not a straightforward remedy, and for that reason, you won't see it used a great deal by creditors. Now, because of the difficulties inherent in execution, your book mentions that there has been sort of an alternative developed, which is to get a turnover order. And basically what that is instead of the onus being on the creditor to send out the sheriff, look for stuff, and all that, a turnover order basically is a court order that says to the debtor, you must turn this over. As a practical matter, if you're the creditor, how do you find out if the debtor has stuff that's not exempt, and how do you figure out where it is? Well, that again is going to be a creature of state law, but typically every state has procedures for what's called a debtor's examination. So let's say you are a creditor and you got a judgment against your debtor for $100,000. How do you figure out what your debtor has? One tool that a lot of creditors will use is they will run a credit report, which gives a tremendous amount of information about a person's employer. It may show them, do you have a mortgage, which will point them in the direction of a house. So creditors may gather information informally, either through credit reporting or other sources of information. What they may also do is they can get a court order requiring a debtor to show up for something called a debtor's exam. And what it is it's very similar to a deposition. The debtor is court ordered to appear and to answer questions under oath. And those questions will be geared at finding out, what do you own, where is it, how much is it worth, and those sorts of things. Now, if you're a creditor, the downside is that you have to pay your attorney to do this. And that can, if you have a low value judgment, it generally is not going to make sense to have a debtor's exam and that sort of thing. But in any event, a turnover order is just another way of trying to execute. It tries to get rid of some of the messiness inherent in executions. However, you still have to have a pretty good idea of whether there's anything out there and what there is that's out there. Now, in the one case in your book that talks about a turnover order, that's the Gerdes case. Basically, the only takeaway from that case is that the court issued a turnover order for property located outside the country as an alternative to execution. So just as kind of a review question, when do you become a secured creditor? Is it when you get the court order saying that you have a judgment? Is it when you deliver that order to the sheriff to execute? Is it when the sheriff levies on property, or is it when property is sold? And the answer is C. You become a secured creditor when the sheriff levies. There's nothing about getting a judgment that makes you secured. There is nothing, just delivering the order to the sheriff is typically not enough because it's a creation of state law. Yes, you might find in a minority of states that that's the case. But typically it's when the sheriff levies. That is the moment when you become a secured creditor in that item of property. Okay, so problem 2.1, which was one of the book problems that I assigned. This is sort of a timeline, I think, that sketches out somewhat helpfully what all is going on in this situation. And so basically, Ace has gotten a judgment, then B got a judgment, B delivered its writ, C gets a judgment, C delivers it to the sheriff, and then there's a seizure. And so the question that you're asked is basically who is going to get the proceeds from this. And so this slide lays out several different choices as far as who gets the money, and I'll give you a second to take a look at those. Basically, there's $150,000 that we anticipate is going to be raised by the sale, and each of the creditors has a $100,000 judgment. So how does the $150,000 get divvied up? All right, and I think the answer here is if we're in a state, so let's say if we're in a state where delivering it to the sheriff is good enough, and I told you that's a minority position, then I think the answer is E. Blake delivered it first, so it gets itself satisfied first, and then Cratchit gets satisfied with the rest. Ace never took that step, so forget about Ace. If we are in a state, well, and in any event, forget about Ace, because Ace, never took any action. So anything that, any of the choices that involve Ace is not a player here. Let's say we're in a state, which is the majority rule, though, which provides that you have to actually execute in order to become a secured creditor. What happens then? Well, then the answer, and it's not one of the answers that's on here, but then I think the answer is that Cratchit, they're the only ones who have done that. They get their judgment paid, and the balance goes back to the debtor, because nobody else has taken these steps of executing. So, Ace is certainly not going to recover here. If state law tells us that delivery is enough, then Blake's first in line and Cratchit's second. If the state law tells us that, nope, you have to execute, delivery isn't enough, then Cratchit's first in line, and any of the balance will just go back to the debtor. All right, switching over for a minute to talk about the Broken Bow case. I told you at the first lecture, I don't want you to get overly hung up on the details of cases and all that, because they're generally in the book not because they are such important cases on their own, but because of the principles they illustrate. And so here, the idea of Broken Bow is it's a fight over a vehicle. The bank lent this person money secured by a truck, and they tried to hurry up and perfect their interest once they figured out that there was a judgment against him. And so basically what happens is that the sheriff levies first, and the bank does not get all its ducks in a row until after the levy. And the principle of Broken Bow is just first in time wins. So bank, too bad. You didn't get everything done. You didn't dot your I's and cross your T's. You should have had that security agreement signed long ago. If you had, and if you'd perfected it by noting it on the title, this wouldn't have been a problem. But you didn't get your act together, and so you got beat out by the levy on the truck. And as I mentioned previously, the other takeaway from the Broken Bow case is that in this particular state, according to this state law, simply asserting dominion is enough. Possession was not required. Okay, so problem 2.2, it's another fact scenario of who gets the money. And in this case, there's a shoe store. your client is owed $50,000. They send the sheriff out. The sheriff enters the store and says, I'm seizing these shoes. But then somehow the shoe store kind of sweet talks your client and says, no, give us a little bit of extra time. Your client is very nice, leaves the shoes there and says, okay, we'll work something out with you. Well, then in the meantime, the bank comes along, takes a security interest in the shoes. Now the business is finally going under. The proceeds from a sale are going to amount to about $200,000. Who's going to get the money? Is it going to be your client or is it going to be the bank? Now the answer amongst those that are up there, without any further information, I think the best answer is probably, well, it depends on how the state defines execution, because we don't know whether this is a broken bow state where it's enough to assert dominion, or whether this is a majority of states where, nope, you have to have possession. So I think the best answer is it depends on how the state defines execution. If we are in a state like broken bow where it is enough for the sheriff to assert dominion, then I'd like you to think about what the answer to that is, and I'll give you just a second. If we're in a broken bow state, then the answer is B, because your client has done enough to become secured in the shoes, and they did that prior to the bank's security interest, so your client gets paid, the bank gets the remainder. If we're in a state where possession is required to effect a levy, then your client has not done enough, and so I'd like you to think about who gets the proceeds then. Alright, if that's the case, then the answer is A. Your client is out of luck. They did not do what they needed to do to become perfected, and the bank snuck in after them with a perfected security interest, and they're going to take everything. Basically, your client shouldn't have been such a nice guy. The follow-up question in the book is, what could your client have done differently and better? And the answer to that is your client could have followed through with the execution, had the sheriff take the stuff. Alternatively, if your client still wanted to give the shoe store a chance to work things out and continue operations, what the sheriff could have, or excuse me, what they could have done was work something out with the shoe store so that they became a secured creditor by virtue of signing a security agreement. And so it could have been something where, you know, in exchange for forbearing on collection, or in exchange for you know, extending the payment term or something like that, we're granting you a security interest in all of our inventory. Those would have been the best ways for your client to improve their position if what they did is not enough according to state law. Going back to this slide of remedies, I do want to briefly talk about one of the other remedies that's on here. We talked about execution. We'll talk about garnishment in a minute. I want to talk very quickly about recording against real estate. Once you are a creditor who has a judgment, one of the tools that you have is to make it a lien against real estate. How you do that will depend on your locality. Some localities, the very existence of a judgment means it's recorded against real estate, both that the person currently owns and that they acquire for a certain number of years thereafter. In some localities, you will have to record the judgment with the recorder's office or the registrar of deeds, or whoever handles that locally. Again, this is not helpful if the person that you have a judgment against doesn't own any property and is not likely to own property in the future. It is helpful if they do. While it may not get you payment immediately, if that person ever goes to sell the real estate, it's going to be very difficult for them to do that because it will be a cloud on the title. Also, if the person goes to refinance, typically the bank is not going to extend a refinancing offer when there are clouds on the title, such as a judgment against the real estate. So it may be something that in the longer term will get your client payment on what they're owed. Very briefly on recording against real estate, it encumbers all the real property that's currently owned or acquired, typically for a certain number of years in the future. It's not open-ended because a judgment itself is not open-ended. A judgment is only good for as long as state law says it's good. And again, that's going to depend on state law. But a judgment is not good for 100 years. It's only good for a certain amount of time. So let's say you record a judgment against real estate and the person doesn't go to sell the property for 25 years. Well, at that point, the chances are extremely good that your state law is going to say that judgment's not good, and so it's not going to be deemed a cloud against title. And so you may have to take steps such as renewing or refreshing that judgment to continue its validity. Generally, the first person to record wins. So a first-in-time system, whoever records against the real estate first is going to have priority as far as a judgment. Okay, so let's turn to the last of the three big remedies for a creditor with a judgment. There's execution, there's recording against real estate, and there's garnishment. And basically the way a garnishment works is that you apply to the court for a writ of garnishment, and then you serve that, or you have the sheriff serve it, on someone you think owes money to your debtor. And they're required to answer some questions about whether in fact they have that money, and if they do, they're required to remit it to you. So sort of a silly example of how it might work. Casey Anthony had a big, highly publicized criminal trial in Florida where she was acquitted. Undoubtedly has very high legal fees, and recently, within the last week, has actually filed bankruptcy. So let's say her criminal attorney, who's Jose Baez, and his picture's there, let's say he sues Casey for his unpaid legal fees and gets a judgment. How's he going to collect the judgment? Well, let's say he learns that she has sold the rights to her story to the National Enquirer for a huge amount of money. He finds out National Enquirer owes Casey money. So he serves a writ of garnishment on the National Enquirer. So he serves a garnishment notice and an order. National Enquirer, even though they're a third party with nothing to do with the relationship between the attorney and Casey, they have to provide, or they have to turn over those funds pursuant to the garnishment order. So that's sort of the general ideas of how a garnishment works in practice. They have to turn it over. All right, and I do want to make sure too to note that garnishment is subject to some limits. There is a federal limit on garnishment, which is 25% of your after-tax wages. When you throw child support in there, that does mix things up a little bit. But generally speaking, for a garnishment, it's 25% of your after-tax wages. Some states, like Illinois, for instance, do have more stringent limits. So they can't take your entire paycheck generally. There are limits on it. And it's also subject to exemptions. So let's say a creditor tries to garnish a bank account. Your state may have exemptions. Iowa, for example, has a $1,000 exemption in a bank account. So they cannot take the first $1,000 that you have sitting in a bank account. Wisconsin does not provide that. It provides a similar exemption, but in any event, there are limits. A creditor still can't take exempt property, even though it does so through a garnishment. All right, so problem 3.1, here's kind of the fact scenario as far as what's laid out in the problem. First, finance gets a judgment, delivers it, there's a deposit. Second gets its judgment and delivers it, and then the writs are served. And so the question again is, who gets the money? Okay, and so the question in 3.1a is, who gets the $5,000? I hope this is pretty straightforward. The answer is C. The bank gets the first $10. They have an offset right. So that should be a tip-off as to why A and B are not correct. The bank gets the offset right. And first comes first because they took their steps before second did. So first gets the $3,000 and then the remainder goes to second. So here the answer is C. Bank gets to do its offset to make itself whole. First took all the necessary steps first, so they're next in line. And then finally second is the next person in line there. Okay, so problem 3.1b, somewhat more complicated fact scenario. First gets its judgment, delivers the garnishment writ, there's a deposit. Second gets a judgment, delivers it, writs are served. Bank pays a check, there's a deposit. The bank answers the garnishment early, and then there's another deposit. And so the question that we're going to have in 3b is basically, again, who gets the money? The book asks about what issues are you going to research. We're not going to worry about that. We're really just wondering, okay, who gets the money given this fact scenario? Okay, so problem 3.1b, who gets the money? I'll give you a second to look at the choices here and see what you think. Okay, the answer is A. Bank still has its offset right. That's why all the choices have $10 to the bank. First still came first. So first gets satisfied with their $3,000. The change here is that second is doing better. They're doing $1,000 better than they did previously. And why is that? Well, let me kind of break it down and see if it helps show you why they do $1,000 better. Okay, so here's why second does $1,000 better. Number one, because the bank wrongfully paid that check. They were not supposed to pay that $500 check once the garnishment writ had been served. And so they're going to have to basically pay that back. They're going to have to compensate second for that. So the bank screwed up in the amount of $500. The other $500 comes because of the deposits that the debtor put in. So a $200 deposit and a $300 deposit. Obviously together you have $500. And the reason that that gets wrapped up by second is because, number one, the $200 deposit came in before the bank answered. And number two, the bank answered early, but they can't contract the net just by answering early. So in other words, they cannot decrease the amount of money that gets into the garnishment just by answering early. So both the $200 and the $300 get swept in. So the bank screwed up, wrongfully paid the $500, has to pay it back, and those two deposits get added in as well. Okay, I'm just going to close once again with this image of the remedies available to a creditor. Again, big takeaway point from today: secured's better than unsecured. Thanks for your patience in listening to this lecture. I hope to see you guys next week. If I can be of help in answering questions or troubleshooting, please either give me a call or send me an email before then. Thanks a lot.